biggest legal threats to assisted reproductive technology right now. Maybe it isn't what you're seeing in the news most commonly. Maybe it's something else. I don't know. I am more than happy to have you on the show if you're from Resolve or ASRM or any of the advocacy groups to talk about what's happening with regard to personhood. I'm more than happy to have that on. But I had Igor Brusil back on the show to talk about a different threat to reproductive technology and reproductive therapy right now. You might remember Igor from coming on the show 2 years ago. He is an embryologist-turned-attorney. He practices in Illinois and Texas. And we talk about not just this change of what anonymity is able to be provided, but what's also being demanded from donors, and where Igor thinks that there is exposure for providers, for agencies, and where the discourse might be lopsided in the legislation that's coming down the pipeline. So we talk about future legislation as what's current, as well as some common mistakes that entities might make or areas where they're exposed. And I think you ought to hear him out on this. It sounds to me like the ASRM should be paying attention to this episode. Sounds to me like for the Fertility Providers Alliance should be paying attention to this episode, because there might be some big time threats coming down the pipeline to donors, to the entire process of third-party reproduction, that either limit its capacity, drive the cost up, reduce donors, just make it really hard for you to be able to treat patients. So I hope that you enjoy this episode with Igor Brusil. And again, if you want to have a subject matter expert come on to talk about some of the other current legislation, please send them my way. Happy to have them on the show. Enjoy this one with Igor. Mr. Brusil, or for those of you that really defend the doctorate of jurisprudence and those professionals deserving that title, Dr. Brusil. In either event, Igor, welcome back to Inside Reproductive Health.
Griffin, thanks very much. You just touched upon some rules of professional conduct. Yes, you can call me doctor so long as you identify that I'm a doctor of jurisprudence, so that it doesn't confuse anyone.
Do doctorates of philosophy have to do the same thing?
I'm not sure.
Do doctors of chiropractic have to do the same thing? I don't know the rules, but maybe they should be uniform. In either event, you're not here to talk about that. You are here to talk about what you see as some I don't know if radical change is the right word, but some very important things happening in the world of third-party reproduction, specifically with regard to I think one of the titles that you recommended for was the death of anonymity, or do we have to give the concept of anonymity a burial service? It was something like that. So I want to let you talk about that. But the last time you were on the show was a hit. Your legal background and your embryology background give you insight into this field that very few other people could have. And so it was popular. But I am in, and I have followed with my resolution to have more people from the lab on the show. So we have more lab listeners probably than when you were last on. But why don't we start with why you felt this concept of anonymity and its going away was so important to talk about?
Well, first of all, my proposed title was Donor Anonymity Gone in 60 Seconds. And I think it's important to pay attention to what goes on, not just in a petri dish or around the incubator or in the incubator, but things that surround it, and legal framework and legal guidelines and standards of care. All of these things are relevant, particularly if you are a licensed healthcare provider, regardless of what license you hold, or if you're a business involved in procurement and use of donor gametes. donor anonymity is a concept that pretty much exists only as a legal theory anymore. In reality, donor anonymity, I would even go as far as say it never existed. Because what's anonymous? If you want to make an anonymous monetary donation, the recipient doesn't know who you are. Donor sperm and donor eggs, the gamete bank knows exactly who you are. So in that sense, you're not an anonymous person. What it was and is becoming less and less a reality is that the gamete procurement facility, let's say a sperm bank, was contractually obligated not to disclose your identity to a third party.
Has that part changed? So I think many people are now familiar with the concept that there's 23andMe, there's social media, there's DNA testing across many different platforms. So anonymous might not be the best nomenclature. Sometimes people use non-disclosed, but has that done anything to change what agencies or if clinics are providing the gametes, what they're responsible for in terms of, should they not even say that they're contractually obligated not to disclose? Has that specific part changed?
Yes, it's changing. It has changed in several states where donors have now a statutory, which is by state law, right to either disclose their identity at the time they start donating or not to disclose. Washington, California have that option written in the law. Colorado, that recently passed a law, was, as far as I know, the third state that passed a donor anonymity law, or at least a law that affects donor anonymity. Colorado does not give donors any option to remain unknown. They have to live with the knowledge that their identity will be disclosed at some point in time. And Colorado law has different provisions when the disclosure must occur or may occur, who may request, so on and so forth. And there are different duties imposed by that law on clinics, gamete banks, as they're called, or gamete matching entities. So yes, depending on where you are now legally required to disclose to your gamete donor that their identity will be disclosed. So yes, the landscape is changing, and it's important for the industry to keep track of that and advocate for the industry's interests. And those interests are, how do we comply with all the regulations that are popping up here and there, and they're all different. So if you don't keep track, if you don't advocate for your position, you will end up with a bunch of different laws in different states, and could be 50. And the logistical nightmare of complying with very different 50 laws would be fairly onerous, I think.
The regulations that are popping up, are they across the board for assisted reproductive technology, or particularly third party, or are there specific laws popping up having to do with obligations to either preserve anonymity or counsel to get informed consent that there isn't anonymity?
Again, each state by constitution is permitted to regulate healthcare in a way that the state legislators deem appropriate. So every set of legislators comes up with what they feel, or someone makes them believe that they feel is necessary. So in Washington, for example, the law applies to certain types of entities that are licensed in that state. Similarly in California. Colorado reaches outside of Colorado. Believe it or not, if you are a fertility clinic that provides, that runs a cycle for residents or a resident of Colorado using donor gametes, Colorado Department of Health will come and inspect you when the law becomes effective, if I'm not mistaken, in 2025. And the legislature,
or that is to say that they are claiming they have, with their law, they have the right to enforce that. So
that's the claim. Yes, legal minds can disagree, and that's good. It means that they're thinking.
On that particular principle, do you think legal minds will disagree? Do you think Idaho will say, no, you're not coming, you're not, no, someone from the Colorado Department of Health isn't coming here? Do you suspect that legal minds will disagree if there are states saying that we do have jurisdiction in other states? Is that a Supreme Court case just begging to be heard?
Well, it depends on who is willing to fight the fight and how far that party is willing to take the fight. It also depends on whether the next level court is obligated to take the case. So there are many wrinkles here, but legal minds will disagree unless they are on something. It's an interesting concept, but just to put this in perspective, if no one challenges the ability of the Colorado Licensing Agency or Colorado State Department to reach out and inspect a clinic, pick a state, New York. If you don't challenge that, here is what might happen. And I'm speaking not from my embryology background, but strictly from healthcare law background. Many physicians that I've dealt with outside of the reproductive arena don't realize how far the licensing board can go in its investigations. The licensing board, or any licensing board, has very wide authority, and licensing boards can come after a person who's not even licensed in that state, or the licensing board of your state can come after the licensee for violating a law even of another state. It's all possible. I represented a physician who dealt with that situation. So it's not just the gamete banks or the agencies or the so-called legal entities. It's real people who need to understand where the law is going and what to do with it.
And so is it almost always that the agency of enforcement is the state Department of Health? Are they sometimes other agencies within a state?
Well, it depends on each piece of legislation, which will define what department of that respective state will have the enforcement powers. In Colorado, I believe it's Department of Health and Environment. Don't quote me on that, but let's assume for the sake of it.
Well, what other agencies are we seeing that aren't the Department of Health when you're seeing either a suit brought forth or an investigation brought forth? What other agencies are doing that sometimes from states that aren't the Department of Health, and what areas do they typically have under their purview?
In my experience, I have only dealt with the licensing board, either responding to a complaint or investigating or starting an investigation based on internal information, meaning there is no formal complaint. But donor anonymity and data about donors doesn't strictly fall under specific laws that address that issue. There are plenty of laws that control how identifying information is collected, stored, disclosed. Biometric laws are popping up left and right. Capture of donors' facial features, like a photograph, may trigger state's Biometric Privacy Act. And in my experience, attorney generals have the right to enforce those particular provisions. So it may be that storing donor photographs in a particular state might trigger liability under the local Biometric Privacy Act, something that I think few physicians or entities think about, but it's there. So there are plenty of areas where collection of information, disclosure, the rights of the donors will matter. It's an evolving area, not necessarily intimately connected to reproductive technologies.
So what do entities have to do to protect themselves?
Well, you know what lawyers do in these circumstances. They suggest
they paint the worst possible picture that doesn't allow you to sleep for nights, and then put forth an expensive solution toward compliance that limits delivery and operations in some way. Is that what you were suggesting? Because that's what I think of.
Not quite. If I were a practice, an IVF practice, donor agency, or a donor matching agency, I would do a comprehensive risk analysis, not necessarily strictly from the standpoint of what is my duty, what do I have to do to collect the information, to whom I have to disclose, but what other laws might be triggered if I maintain this information. Is there a conflict of laws? If one law says you have to disclose donor information and the other law says you can't disclose donor's facial features like a photograph without a specific consent of the donor, well, you need to have some serious analysis where you fall. I mean, you may not be subject to multiple laws because you fall under the exception, or the facial features are specifically exempt. The type of features that you maintain are exempt, but you can't just disregard that blimp on your legal radar. You have to follow up. And what needs to be kept in mind is that the push to remove donor anonymity, completely eviscerated, is coming from the donor-conceived community, as far as I can tell. It's the biggest voice in terms of additional regulation of the IVF and ART industry with regard to donor gametes. And if you read their positions and convictions, it's not just the donor identity that they seek out, or at least they claim that they have a right to have. They want medical information, not just of the donor, but about the donor. And about the donor includes family members. And I think time has come for the industry to sit down and address the elephant in the room. And the elephant in the room is that, number one, the entire conversation is driven by one party that has very one-sided goals. And if you really think hard, without all of the political filters of political correctness, what it would take to achieve those goals, you'd realize that in reality, you'd have to pick up novel 1984 and add a chapter for Department of Reproduction. Because the most vocal community that's driving this conversation insists that children have a right to know not just the identity of their biological parents, but their medical history, their social history, their mental health history, and those histories of several relatives. New York State is now considering a law, it's in one of the committees, that would require certain players in the IVF industry to collect information from the donor about the relatives, 3 degrees of consanguinity.
So when you're saying that this is entirely lopsided, the conversation is on one end, you're talking about from the donor conceived community.
And I'm not making any judgments on whether their claims are valid or not. I'm taking them as they are. I'm not an ethicist, so I'm not going to make any judgment. But if I take those claims and I think, what would it take? For example, they very frequently complain that clinics or gamete banks or agencies don't verify the information that donors provide. My question is, and it's a serious question, how far do we want to go? There has to be some legal framework. It's one thing to ask for a driver's license. Okay, how do you verify that? To what length do you have to go? I mean, do you have to register with e-verify? You may not be able to because you may not qualify as a gamete bank to register. I have it on good authority that getting a fake driver's license is not such an issue. College kids, more than one, have told me, yeah, it takes about half an hour, and we can go get some beer. So if every step of the way, the question is, how do we verify? How do we follow up? You're going to run into a situation that would require a full-on dictatorial regime. For example, states require gamete banks to collect donor family history. New York goes as far as requiring names of doctors. Again, it's not a passed law, it's a proposed bill. Names of doctors that the donor has seen in the preceding 5 years. All right, fine. So you've got a list. Dr. Jones, Dr. this, Dr. Brusil, you name it. How do you verify that? What if there is another physician whom the donor didn't disclose? So then the question is, okay, the donor lied. What do you do with that? Do you sue the donor for fraudulent misrepresentation? I mean, you have to literally take this to an extreme and it's.
Well, I guess that's going in the contracts, right? It's going in the contract with the donor that everything that they say is true, and then I suppose that it's going in the contract with the intended parent that we had the donor sign the contract that everything they said is true, but we cannot. But there's limits to how far we can verify what they've said is true. Is that going in both contracts?
It's not just contracts. Contracts are good. You can write up what seems like a very solid contract. The question is, are you willing to enforce it? In other words, you can have all the promises made by the donor given under oath. But what do you do if the donor breaches the contract? Are you willing to go and sue the donor? I mean, you have to look at the entire process to come up with a reasonable solution, not just follow what one side is promoting, and then you end up with laws that are you just go, well, how do you comply with that?
I'll ask it a different way. Is it wise to or necessary for the contract with the recipient, the intended parent, to declare the limits to the enforcement?
I have to be, again, if I were someone like a sperm bank, let's just use the word sperm bank, because it's, for some reason, it pops up in my head far sooner than any other term. If I run a sperm bank, I would have to tell my customers who buy donor sperm, we can't verify what the donor is telling us. And at this point, you can't, because there are legal limits to what you can compel the donor to do. You can't just waltz into a doctor's office and say, look, the dad of our donor is being seen here. We'd like his medical history, because the donor would not cooperate. You just can't do it. And there are other developments that, in my judgment, would drive the decision-making process of if I were the sperm bank. For example, there are two very relevant court decisions, one in Oregon where a donor sued the sperm bank and the claim of fraud was the only one surviving. So the court permitted the claim of fraud to go forward. And the multiple lawsuits in Georgia filed by recipient parents alleging that the sperm bank did not verify certain information that the donor provided. And what those two cases tell me is that the courts are doing what, frankly, is a very logical conclusion. They're treating donors and recipient parents as consumers. And they're applying very generic fraudulent misrepresentation legal theories to make sperm banks liable. So if you tell someone, this is what we do, but we don't actually in reality, you could be liable. If you don't fully disclose what you do or what you have to, you also could be liable. So this coin certainly has two sides. On the one hand, you have to tell the donor, in my judgment, that the donor information will be disclosed to someone pursuant to such and such law. You can't, I think it's insufficient just to say, well, it's all confidential, but we might have to disclose it pursuant to law. Well, it doesn't tell the donor anything. On the other hand, you have to be truthful with the recipient parents and say, we are limited in our ability to verify. And at some point, someone would have to take responsibility, but it's a separate conversation, I guess, to what extent a sperm bank would have to go to verify. Again, I just don't know if there is a good answer, because there are privacy laws that would have to be completely demolished. There are laws regarding access to donors' information and history that would have to be demolished. So sperm banks would have to be given unfettered access to whatever they feel they need to find in order to satisfy this one-sided drive for disclosure of information. So it's a tough situation.
Is your bigger concern at this time is that entities are too exposed within the current framework, or is your biggest concern of the legislation that may pass that may make it untenable to either operate or to comply?
Both. Frankly, both. So let's just assume, for the sake of the argument, no state has passed any laws regarding mandatory disclosure of donor information, or mandatory collection, or mandatory storage and maintenance forever. Let's assume those laws don't exist. You still have, in my opinion, legal responsibility to be honest with everyone involved. Just a couple of days ago, when I was preparing for the podcast, I opened up a couple of websites that belong to very notable sperm banks, and I looked at the description of services for donor sperm. And one bank says it's 100% confidential. Just flat out, 100% confidential. Well, if you're splitting legal hairs, and what you mean by 100% confidential is that we, the sperm bank, will not tell the parents, well, maybe, but not in the current climate. I wouldn't make such a statement. Then I looked at another one, similar commitments to ironclad anonymity. I mean, no way, no how, nowhere. And then at the bottom, well, recipients may look you up online. All right. Again, if I were driving the bus, I would take greater precautions. I would be open.
Does advertising like that present a liability even if the contracts are airtight? So if advertising such as what you just described is contrary to what's in the contract, can the person argue, well, I didn't have consent because unlike this 18-page document that I was supposed to read through and sign everything. It's right here, right on the homepage. It says we have ironclad anonymity. So how much does or does not advertising like that jeopardize a really well drafted agreement?
I'll give you a typical answer you'll hear from most lawyers. It depends. And it depends on several things. Number one, statements that people make or entities make are subject to a tort legal liability theory, which is different from contract liability. There's a completely different legal theories. You can pursue tort claims and contract claims at the same time. There are different recoveries. It's a very complicated and convoluted conversation. But to your point, yes, you can get in trouble for advertising one thing, even though your contract is bulletproof. And I'm using, Dr. Evil's bulletproof. Contracts are not bulletproof. That's just sad reality. So yes, you can, absolutely.
With regard to entities, who do you think is generally more exposed right now? Does it tend to be providers or does it tend to be agencies?
Well, I think it depends on who has the greatest interaction with the donor, who communicates with the donor more than the other party. So let's assume, for the sake of the argument, you are a sperm bank in my state of Texas, okay? And you collect sperm here, you process it, you deal with local donors, then you ship it to a clinic in my former state, Illinois. All right. So the Illinois clinic most likely will have no interaction with the donor. Probably none. So their responsibilities, their duties and risks probably will be less, but it doesn't mean that someone in Illinois wouldn't say, oh, it's donor sperm, it's 100% confidential. There is no way, this could come out. Well, it could. It took me literally 5 minutes yesterday to find out how I can plug in a photograph and find matching or similar images on multiple social media websites. Life has changed. 20 years ago, most people didn't have substantial social media presence. Today, if you're a professional and you don't have Facebook, LinkedIn, Instagram, or some other outlet, your marketing specialist will tell you you're a dinosaur. So, yeah, the risks are everywhere, which brings me to my suggestion that you have to sit down and conduct a professional and thorough analysis of your risks and take it from there. The answer will depend on your risk tolerance or risk aversion.
We're talking a lot about consent in this episode and what might threaten informed consent. I'm not an attorney, but you should talk to your attorney about what informed consent is provided by Engaged MD in a way that isn't when you just slide a stack of papers to someone. Are you better protected by having someone sign a stack of papers with a lot of language that they don't understand, or are you better protected when it comes to informed consent when the recipient has gone through video modules, they sign off on each one, they take a quiz? Who's the more informed party in that situation? Again, I'm not a lawyer, but why don't you talk to your lawyer about this so that you can get on Engaged MD if you're now in the minority of practices that isn't using Engaged MD. Often I talk about it for workflow and for reducing burden to staff. It does all of those things too. Also might protect you a lot more and remove some liabilities. So you want to look into that. Go to engagedmd.com/Griffin. You got to spell my name right. It's Griffin. My name has never been Griffin. It's never been Griffin. It's engagedmd.com/Griffin so you can get a free workflow consult and ask them about some of these things. Ask them about this particular phase with informed consent. Use this as an opportunity to get a little bit of free insight as to what other practices are doing. Go to engagedmd.com/Griffin, get your free consult. Do clinics and that is said, do providers and agencies tend to have the same, do they tend to make the same mistakes? Do they tend to be exposed to the same, like the very same risks? Is there some differentiation between the two, or does that not matter because it has to do with the intended parent and the donor?
I think the risks are similar. They may risk for someone who constantly interacts with the donor to follow up on a red flag in the donor's history. That risk would be the greatest for the sperm bank that deals with the donor compared to a fertility clinic that's just using the donor. And speaking of risks, the New York proposed legislation would require a physician, medical director, to issue a written certification that he or she basically certifies whatever the physician certifies. So it's a different level of liability when you have to do something in writing pursuant to state law. So the risks are going to be there, but they may not be as great for one party as opposed to the other. So that would be my answer, if it makes any sense.
My audience is going to be, at least a part of my audience is going to be ticked off that I haven't covered the implications of the potential Roe versus Wade overturn, and then what's happening in state houses, often related to that, and that I brought you on to discuss a different reproductive legal issue first. I know that's going to tick a couple people off. I'm one man, people. I've got a show, and it's part of what I do to run my business like everybody else. I'll get to it if you send me some experts, and we could even and possibly have Igor back on to talk about that. But I want to ask you, Igor, do you view what's happening or has the potential, what's happening in state houses right now with regard to personhood, possibly connected to the potential Roe versus Wade overturn, as a bigger threat to assisted reproductive technology right now? Or do you consider this concept of anonymity a bigger threat?
I never thought of it that way. I think anonymity would probably be a far more acute issue for me if I were, to decide which one is which. Personhood bills have a history of not being passed. Abortion debate involves termination of an existing pregnancy, whereas the IVF industry does not deal with an existing pregnancy. It deals with a pregnancy that doesn't exist.
They would say, well, but people are very worried that laws that talk about embryo as a person then put REIs in jeopardy of, well, you can't cryo freeze people, you can't discard people, and so that puts all of IVF at risk.
Well, I certainly understand the worry that people have. I think I wouldn't be, that's my personal opinion, I'm not that much concerned at this point, having seen the legislation that's already in place. I can certainly imagine arguments if, for example, state law declares a legal person from the time of conception. As an embryologist, I'm thinking, okay, when does that start? I can't see it. When is it? Is it 10 minutes after I did ICSI? Is it an hour? At which point, if I discarded the injected oocyte, did I just violate the law or not? It's just take it to an extreme. But I'm not that much concerned. But anytime legislators start writing things, you have to be concerned, no matter what they write. And I am personally concerned about just about anything. When I was a law student, I was involved in educating Illinois legislators on the issue of genetic privacy, because there was a desire to create a statewide health information exchange. And there were different laws covering different types of medical information, genetic, mental health, everything else, that made that project questionable. And I did a presentation for the legislators. One was yawning. The other one picked up the cell phone, and walked out during the presentation. The other two looked as if they were just ready to walk out, and expressed absolutely, at least their facial expression was, "Who cares?" So you're certainly, I think, you're going to run into legislators who write things for the sake of writing. As sad as it is, plenty of laws that I've read on many subjects, you wonder who wrote it. So that's where we are, unfortunately. And it's not just limited to abortion or IVF or anything else.
But I don't hear this topic coming from the reproductive health advocacy group nearly as much. The topic of anonymity and the obligations therein. I'm not saying they're not talking about it, and this could be my own limitations, but I'm not hearing. I hear lots of concern, and not just from this most recent Supreme Court concern, but from ever since I've been in the field. The advocacy has had to do more with, at least when we're talking about reactive advocacy, or perhaps protective advocacy is a better word. Having to do with legislation that touches abortion. I don't really hear people talking about making sure that we're educating legislators about the actual constraints of anonymity and what's involved in delivering. Are we missing something as a field across the board?
I don't think, certainly you're not missing anything. I have it on good authority that you are thoroughly plugged in on the industry. And I think you just nailed it on the head, the snail. I looked at the minutes of the meeting held in Colorado when the Colorado Act was being debated. And there were some attorneys, local attorneys, very well known in the ART space, who, according to the minutes, testified on their own behalf. There were donor-conceived persons who testified on behalf of the entire donor-conceived community. There were ethics law professors who testified in favor of the law. I did not see a name that said Dr. Such and Such testified on behalf of name, a physician interest group, or such and such person on behalf of name and interest group on behalf of sperm banks. There may have been one sperm bank manager or an owner, I don't recall, but I think you are onto something very important. There is not much discourse on this issue. There's not much debate, and I don't know if there is some reluctance to even voice an opinion that doesn't jive with the one-sided narrative, for fear that it might be, what are the terms that are common these days, a microaggression, or something that you're insensitive, or you're ignoring the fundamental rights of donor-conceived persons. Again, I'm not making any judgments. If they feel they have a right, let's have a discussion on how that right could be implemented, for lack of a better word. What I would like to, frankly, now that we are discussing it, I wonder why only donor-conceived persons should have that right. Let's assume they should. I mean, the donor-conceived, I just read it half an hour ago, when slightly more, just to confirm my suspicion. One of the very vocal groups says that donor-conceived persons have a fundamental right to know the identity and the medical history of their parents. Why only donor-conceived? I mean, it may sound like a silly question to you, as most of us, well, it's my dad, I know who he is. No, you don't. You assume that you do. But chances are, at least I wasn't present when the gametes were in the intimate vicinity. I wasn't aware of my birth. For all I know, I could be adopted. My parents never told me. But with the same token, the donor-conceived persons, as they term themselves, are getting statutory rights to demand medical history of people they don't know, donors, and their relatives. I don't have such a right. I can't just compel my parent, one is deceased, to disclose their medical history. I can't do it. It's a personal issue to me. My father passed away, and I'm thinking, had an illness that had a genetic component. I'd like to know what it is. I can't do anything about it, because he signed an authorization basically saying, don't disclose to anyone. End of story. So if children have a right to know everything about their biological parents, including their medical history and that of generations of relatives, why should that be limited to only donor-conceived? Just a question for a discussion. I know it wasn't the topic of the conversation, but in my mind, it is intimately, for lack of a better word, no pun intended, linked to this entire conversation that we're having. Well, you're right, there is not much conversation.
I really don't think so. And so for all of the advocacy folks, I'm happy to cover the issues that you want, and you can send your experts on the show. But I also suggest you might consider this issue more, because I can see broad-reaching implications regarding anonymity, and I just don't hear us talking about that nearly as much. You've said, Igor, that you're not the ethicist, and I think that's probably why you're a good attorney, is that you're very dispassionate and you look at the law, and what you're seeing is that it's lopsided right now, and here are the risks from the discussion being lopsided at the moment. So if you're not the ethicist, who should be arguing the other side of what's reasonable? So it's reasonable to want certain things as a donor-conceived person. It's reasonable to want things as a donor. It's reasonable to want things as a provider. So all things are a negotiation. At least they should be. When they get bent to one party gets a preferential treatment, then we've lost what I perceive to be a law-following republic. But who who helps that negotiation along, and what do parties need to do to advocate for themselves?
They need to advocate for themselves. You just answered your question. The parties know exactly who they are. The parties know exactly.
Meaning the agencies, the providers, the
clinics, the agencies, the gamete banks.
Well, here's the but is there any alliance for donors? Probably not, right? Maybe I'm making an assumption, but
I'm not aware of it.
Right.
I'm not aware, and I've put myself in a position of a donor many times, mentally, as a mental exercise, and I asked myself, would I, as a donor, want to know what exactly are my rights? I mean, several states now permit donors to be a disclosed donor, meaning they will sign a piece of paper that says, I permit you, sperm bank, to tell the recipient couple who I am. Fabulous. But those laws don't allow the donor to go back. and pull that authorization away. I have a fundamental disagreement with that approach. Fundamental, but again, it's an ethical question. So donors, if they say, I don't want to be disclosed, they can later say, fine, I agree to be disclosed. But once you say, yeah, disclose, you can't go back and say, no, don't. I have not seen anyone advocating on behalf of the donors. And I see a very good reason why donors may not want to have any right taken away from them irrevocably, like a right not to be disclosed.
But donors aren't going to be advocating for themselves because so many of them don't want to disclose their identity. So then I get the providers, the agencies, but they have their own needs to advocate for, right? So is this naturally going to be an imbalanced debate?
Most likely, yes. Unless some entity, some person, some organization, I don't know what it might look like, decides to advocate on behalf of the donors and have a real discussion. There's no discussion. There are demands and responses to demands on the part of several legislators, legislatures, and kind of a reflex-like conversation within the IVF community vis-a-vis, a recommendation or an ethics opinion from ASRM. That's basically as far as we go. I haven't seen a discussion. I'd pay any money for a town hall discussion with donor-conceived persons on the scene and players in the ART community. A discussion that basically says, fine, we recognize you have those interests. What would it take to satisfy your demands? Tell us exactly what is it that you would think matches all of your demands, and have a discussion. And there will be, I am guessing, dozens of issues that no party can implement in the current legal environment and framework, unless you have a Department of Reproduction that controls every ovulation and every ejaculation and knows what goes on, and we're becoming a dictatorial state in terms of reproduction.
What involvement has the ASRM had in this legal advocacy up to this point?
I think it would be inappropriate of me to speak for ASRM. I can only see what I can see published. I'm not privy to any discussions, so I just probably a week ago or even less, the latest issue of Fertility and Sterility published the latest ethics opinion on issues related to donor anonymity. And there is a suggestion that donors should be provided legal counsel, legal consultation before they donate. You know what? I am ready to say, at least to myself, they should be represented by an attorney. We are at a point where in third-party reproduction, everyone is represented by an attorney, but the donors. So there is recognition that legal rights and obligations are involved, and just about everyone is represented. But the donors, I didn't see any.
Well, that would really cut down on donors, wouldn't it? Especially if they had to pay their own legal expenses, because then the question is, well, who pays the legal? Do the intended parents pay the legal expense? Wouldn't there be a conflict? Do the provider, does the agency? Is there a conflict there?
And that's why I think what we do not have currently is a serious discussion where uncomfortable issues are brought up and discussed. I do realize that we'll live, in a time where Play-Doh and petting zoos and safe spaces are becoming commonplace because everyone is offended. by whatever you say. I'm sure there will be people who will be livid when they hear this podcast if you decide to post it, because they would feel that I offended them. Well, human interaction invariably leads to one side being offended, and there will be the offendor and offendee in legal terms. I just made that up. But if we're not prepared to have a serious discussion, then we're going to have, with a patchwork of laws, one in this state, one in the other state, that will drive up the costs, that will create uncertain risks for everyone involved. And the community pushing for more rights will still remain unsatisfied, because you can't compel donors to do what they're asked to do. You just can't. There is no legal mechanism to compel a donor to disclose all of the physicians that he or she had seen, to name all of their relatives, to bring verified medical records of all the relatives. There is no way to get to a point that the donor community wants to get to.
So, as far as you know, is there any decrease? I should know this, but I don't know this. I've got my finger on the pulse of, transfers, retrievals, egg freezes, that type of thing, but I don't know if there's any decrease in donors. It doesn't seem to me that there is one, because our clients are, when they engage us, it's almost always to get more matches, to get more recipients. So they seem to be stocked on the donor front for both oocytes and sperm. But as far as you can tell, is any of this risk to donors leading to a decrease in donors, or has that not happened yet?
The answer is, I don't know. The first part pertains to how many donors there were and how many there are now. In order for me to answer that question, I would have to have all of the confidential info of every sperm bank or every egg in front of me, so that I could add things up and compare them in real time. I just don't have that. What will happen in the future, I don't have the crystal ball. There are certainly arguments that fewer donors would be willing to donate, and there are arguments that if there is a decrease, it's not going to be a substantial decrease. I just don't have the crystal ball. I don't know. And I'm speaking simply as a member of the community. I observe that current generation does not value privacy as much as the prior generations. So it may be that the donors of today simply just don't care. You can find me on LinkedIn, Facebook, Instagram, TikTok, you name it. Fine. It doesn't bother me. So it may come to a point where donors couldn't care less, and there isn't going to be any change. But my expectation is that if all of these laws are complied with, number one, the cost of donor sperm vial or eggs will go up. By how much, I don't know. But say in Colorado, you have to, if you're conducting business in Colorado, if you're licensed in Colorado according to that law, could be a $500 license. Plus they want to inspect, so they require a compliance plan and remedial plan. So somebody would have to create that. That's an additional cost. Anytime someone does anything within the organization, there's a cost attached. So sperm is not cheap today. It could be $1,000 a vial plus $300 for shipping, plus incidentals, blah blah blah. You're looking at a $2,000 vial. If you have to spend more money on compliance, guess what? The vial is not going to be cheaper.
So I want to let you conclude with some parting advice. An attorney, let me do the disclaimer for you. You can do it again if you want. It's not legal advice. I guess some insight as to what people should think about doing next, for what they should be looking into. I guess suggestions as to what they should be looking into as far as how they should protect themselves. We do have some agency owners that listen to the show, but it's more REI practice owners.
Well, if I were any one of the persons or entities you just mentioned, I would look at the current laws in my state and find out what other states have laws that are relevant. And I would certainly retain an attorney who is experienced in healthcare and privacy, because as I mentioned at the onset, there could be laws that are not specifically IVF or ART or reproduction related that might trigger certain legal concerns. And if I'm a physician and I'm speaking based on my experience outside of ART arena sphere, I would not take lightly all of these risks and responsibilities, particularly when it comes to being truthful with whoever you are dealing with. Because I've defended physicians and dentists and other not licensed healthcare providers. The boards will come out, and if a board takes disciplinary action in one state, it is required by federal law to upload that information into the national database, and the licensing board in a different state where the physician is licensed will most likely conduct periodic reviews of that database. And if that ding from a different state pops up, guess what? Your state's licensing board now gets involved. So is it a remote possibility? It's a possibility. It's a very real possibility. And in my experience, physicians don't even know how far the board can go, how deep the board can dig. That's an issue. If I am running a sperm bank or an egg bank, well, sure, I, as a businessman or a businesswoman or a business, I'd like to know what the rules of engagement are. And if there are 50 rules, then I will have to make a business decision which states I will operate and which I won't. Or I will have to make a business decision with regard to donor screening and pricing. And anyone who is involved in this process should do a legal self-reflection, preferably, as self-serving as it may sound, with a licensed professional. So that's, I think, is my advice on that. And the conversation needs to be maintained. It can't be a one-sided train where one party is, at the helm of the locomotive and drags the train and lays the tracks in the direction that it wants. That train will soon run you over if you don't.
Well, this is a good episode for the ASRM to listen to. It's a good episode for the Fertility Providers Alliance to listen to. For those of you that want to get in touch with Igor Brusil, his website is brusillawgroup.com. Brusil is Brusil, brusillawgroup.com. Igor Brusil, embryologist-turned-attorney. Thank you so much for coming back onto Inside Reproductive Health.
Thanks, Griffin. It's been a pleasure. Thanks very much.
You've been listening to the Inside Reproductive Health podcast with Griffin Jones. If you're ready to take action to make sure that your practice thrives beyond the revolutionary changes that are happening in our field and in society, visit fertilitybridge.com to begin the first piece of the fertility marketing system, the goal and competitive diagnostic. Thank you for listening to Inside Reproductive Health.